Welcome to Court Helicopter Explainers. We have decided that we need you to know Court Helicopter is a media house that covers live proceedings in court. Many of the people who are accused come to court and say, I didn't know that that was an offense. I'm sorry. I didn't know that. Then the courts always tell them, why don't you ask Court Helicopter to teach the Kenyans that there is a law under Section 7 of the Penal Code where most criminal people are charged. What does that law say? It says any ignorance of the law is no defense in a court of law. So we decided, now that Kenyans are ignorant of the law, and this is biblical. The Bible says, my people suffer because they don't know. If they knew, they'll not suffer. So that biblical teaching is what we looked at Section 7 and said, any ignorance of the law is no excuse for an offense committed. So we decided we shall be bringing you live episodes of what the law talks about it. Welcome to Court Helicopter. Today we are on chapter 10 of the Penal Code. The Penal Code is the list of offenses in this country and the punishments provided for. All crimes are found in the Penal Code, and today we are starting with the crimes in the administration of justice. These are crimes committed in court. Do you know you can commit another crime in court? You are arrested, then you commit a crime in court. 2, are you a complainant who has complained and somebody has been arrested? Do you know you can also be arrested and be charged, yet it is used as a complainant? Do you know when you are testifying in court, if you give false evidence, you can be arrested and be charged? Have you ever said, Vivian stole your bread, and Vivian never stole your bread? And when you reach in court, Vivian, your complaint is on the dock. Then as you give evidence, you are also arrested and the two of you are put in the same dock. Have you sworn an affidavit saying that Bramwell is your boyfriend, or you are married to Bramwell, and you know very well Bramwell has never married you, and you present that affidavit somewhere? Then you come to be arrested late, you sue Bramwell for child support. Then Bramwell says, that is not my affidavit, that is not my signature. Then you are also arrested and brought to court. Have you ever known that you can easily be jailed for lying to the court? Do you know what are the implications when you stand and take the oath? You are a Hindu, you raise your hand and say, me, Patel, I swear under the Hindu Act. Mimi, I'm a Muslim. You carry the Quran and swear under the Quran. You are a Christian, you carry the Bible and swear under the Bible. You are an atheist. You raise your hand and say, I don't believe in God. I affirm myself. You are a traditional African practitioner, and you say, you swear by the cultures of the Mijikenda, the Mujurinjeke, the Mungu wa Kikuyu and the others. Keep watching. Today, we are bringing you how you need to take your tracksuit, your running shoes, and run away from crime, because crime is now very expensive. Welcome to chapter 11 relating to, it is not chapter 10, chapter 11, relating to the offences relating to the administration of justice. Section 108 talks of perjury and subornation of perjury. Perjury. What is perjury? A. Any person who, in any judicial proceedings, or for the purpose of instituting any judicial proceedings, knowingly gives false testimony touching any matter which is material to any question then pending in that proceeding or intended to be raised in that proceeding is guilty of a misdemeanor termed perjury. If you lie and you know it by lying, one, in an affidavit that is going to court, you lie on oath. Remember, an affidavit, you do it under oath. The commissioner of oath, the advocate commissioning that, is a commission of oath. You take an oath, then you lie. And that affidavit goes to court. Or you stand in court, you take an oath, the way we have said the 5 types of oath, and you lie. That is perjury. 2, any person, it says it is immaterial whether the testimony is given on oath or any other sanction authorized by law. So long as that evidence is in an affidavit or in court, it is perjury. C, the forms and ceremonies used in administering the oath or in otherwise binding the person giving the testimony to speak the truth are immaterial if he assents to the forms and ceremonies actually used. It is immaterial whether the false testimony is given orally or in writing. Whether you are trying to say, sorry, I just gave this evidence orally. My friend, it doesn't matter whether it was oral, whether it is in writing, so long as that evidence is produced in court and it is false. It says, any person who aids, counsels, procures, or suborns another person to commit perjury is guilty of the misdemeanor termed subornation of perjury. The one who gave the false witness will be charged with the offense of perjury. The one who assisted him, if you knew that this man, this woman is giving false evidence, and you assist him, you advise him to swear a false information in an affidavit. You advise him, this guy is disturbing you. The two of you are buddies as girls, the two of you are buddies with boys, then your friend is being taught, then you say, no, why? Let me do this. Let me draft this. Let us allege this man is a rapist. Let us allege this man is a lesbian, this woman is a lesbian. Let us frame this person. You draft an affidavit, the person signs. If you assist somebody to lie in court, if you assist somebody to swear a document that is false in court, you will be charged with an offense called subornation of perjury. And if you are found guilty, you will face the consequences. Section 109. Court Helicopters brings you this every time. Keep watching how Court Helicopter brings it out. Have you ever been taken to court and you don't know English? You don't know Kiswahili? There needs to be an interpreter. What happens? You have gone to another country. You don't know English. You don't know Kiswahili. Or you are in this country and you never went to school. Wewe hukwenda shule na ujui Kizungu na magistrate ajui Kizungu. lazima translator, kwa Kiswahili inaitwa mkalimani. Lazima mkalimani aitwe akuje kutafsiri. Basi wewe umesoma Kizungu yako na umesoma Kiswahili na wewe ni Mjaluo, unaitwa kwa mkalimani. So the interpreter has been called to court. But the interpreter, who is you, is not interpreting what is proceeding in court. He is interpreting his own things or her own things. Ule mkalimani badala ya kutafsiri vile ilivyo yale yanayosemwa, anatafsiri kwa sababu ni rafiki yako, anadanganya mahakama. What happens when an interpreter in court misguides or interprets wrongly? False statement by interpreters. Section 109. If any person lawfully sworn in as an interpreter in a judicial proceeding willfully makes a statement material in the proceedings which he knows to be false or does not believe to be true, he shall be guilty of perjury. Basi yeye huyo mtu wako atashtakiwa kwa kosa la perjury, kudanganya mahakama. So any interpreter, you now know, if you are training to be an interpreter, if you falsely interpret, you'll be arrested there and be charged with the offense of perjury. What is the punishment of perjury? Under section 110, any person who commits perjury or supports perjury is liable to imprisonment for 7 years. My friend, if you lie to court, you are going in for 7 years. If you swear an affidavit that is false, now you know you are going in for 7 years. Let me tell the people, for example, in laws of succession, when parents die, people swear an affidavit that my father had only one wife. That's my mother. When your father had 5 wives, you don't disclose that. And you go and get letters of grant pretending that your father had only, or your husband had only one wife. 2, when an accident happens, for road compensation acts, you swear an affidavit that I was the driver of the car and there was nobody in the vehicle. Then later, there are 5 people who come later to say, we were in that vehicle, we were injured. Next, you swear an affidavit in a children's matter. You want to go out of the country. You want the father of the child not to be involved. You swear an affidavit saying, I got this child and the father of this child died in a road accident. He was a truck driver from Mombasa to Congo. He died there in the Congo War. When the father of that child is alive, you get to leave the country, you get to go outside with the children. It is very interesting. You swear an affidavit that I know this person and this person is good when that person is not good. Any affidavit that you swear, any information to court, if you lie, you are going in for 7 years. It is an offense of perjury. When you stand in court and say, I saw him kill this person, I saw him break into the shop, I saw her snatch the bag or the necklace of another girl, I saw that person, when you never saw, you are not even there. When the CCTV is brought, then you are told, show us where you are. You are telling us this. Now here is the CCTV. It shows different issues. You lie, you were present. Then your phone, the GPRS is brought to court. You were in Mombasa and you said you were in Mushatha, you were in Ruaka, and you saw how that offense was committed. You now know. Advocates wear suits. Omari wear a suit. I have worn my sport shoes, my track jacket, because I want to tell you, change and run away from crime. Because now you know. You are not aware that lying to court can land you 7 years. Wakili Danstan Omari keeps on warning you to proceed. Then we go to evidence of perjury. Then we go to the contradictory statements. Section 112. A contradictory statement. You say this, you say this. You say it white, shortly you turn, you say it in red. You contradict yourself. A, where a witness in any judicial proceedings has made a statement on oath or affirmation of some fact relevant in the proceedings, contradicting in material detail a previous statement made on oath or affirmation by the same witness before the same court or any other court or tribunal. Such witness, if a court is satisfied that either of such statement was made with intent to deceive, is guilty of an offense and is liable to imprisonment for a term not exceeding 2 years. Have you sworn a statement? You write a statement to the police. That statement, you write it in 2020. You come to court. You run away from the statement that you said in writing. You change now to another statement because you have been bribed. Or because you have reconciled with the person you wrote a statement against. If you tell the court one thing, and you tell the court another different thing, you will go in for 2 years. 2, if you tell one court this thing, divorce proceedings. We do a lot in Danstan Omari and associates, a lot of divorce and a lot of division of matrimonial property. If in divorce, you said this against your husband or against your wife, then in division of property, now you are saying different things. For example, in the divorce proceedings, the woman is saying, I have no interest in the properties. All I need is to be divorced. I even never contributed anything. My job was to keep my man happy, because I wanted to be a good wife. In matrimonial causes, you are saying you contributed, you took loans, and you contributed into this property. Your husband brings your proceedings in the lower court where you said you contributed nothing, and now you are saying you contributed this. That is contradictory statement. Any statement in a court of law applies to all other cases. You cannot select which statement to tell this court and which statement to tell that court. So be very careful. Contradicting statements, the courts take it that you want to deceive the court and you'll go in for 2 years. That is first example. Secondly, it shall not be necessary to prove whether it's true or not. So, for avoidance of doubt, avoid giving contradictory statements, either orally or in writing to court, or else you'll go in for 2 years. Section 11.2, Section 112A, malicious information. Have you ever given to court anything that is malicious? Malice, it is when you have a premeditated mind to hurt somebody. You have planned to hurt somebody. When you shall be dealing with murder, we'll be talking about malice aforethought. You have planned to kill somebody before you kill. You have an intention. You have a motive. So malicious information, 11112A. Any person who, with intent to cause harm or inconvenience to another person, gives or makes to any magistrate or member of the police force. In malicious information, what does the law say? Any person who with intent, mark the word, intend to cause harm or inconvenience to another person. This person, you don't like the face. You don't like the voice of this man. You don't like the way she dresses. You don't like the car she drives. You don't like her tribe. You don't like that person at all. You plan to inconvenience that person. You plan to hurt that person. So you go to court and you say, you give to any magistrate or judge or member of the police force the following: any officer having power to apprehend or order the apprehension of offenders, any information or complaint in relation to that other person that he knows to be false is guilty of a misdemeanor. And if that person is found and is arrested and occasioning bodily harm. So the question is, have you ever given false information to a magistrate or to the police? Have you ever gone to the police station and you know it is not true, but you made a complaint against this person and that person is arrested? Have you yourself complained against somebody and you know that person has done nothing and that person is arrested? What will be the consequences? We'll tell you. Giving false information to somebody in public office. It goes on to say, if that person, for the purpose of this section, if that person gets harm or that person is killed, it shall be deemed to have resulted from an offense under this section if the court is satisfied that, as a matter of fact, and without regard to the actions or motivations of any other person, that the offender, the harm would not have been done, or the death would not have occurred, as the case may be, if the offense had not been committed. Have you gone with your girlfriend to an Airbnb, or your boyfriend to an Airbnb, and you have differed, and you rush out and start saying, he's killing me, he's killing me, he's killing me? People come and kill that guy. Have you ever shouted that somebody is a thief on the street because you have differed? The public kill that person. Have you made your husband to be harmed, beaten badly because you said he has done a certain offense? My friend, kusingizia mtu. Umewahi singizia mtu na akadhulumiwa vibaya sana, and you go happy and celebrate, umwambia, si nilikwambia unacheza na mimi naweza kupanga na nitakupanga, na umepanga mtu amepigwa. My friend, let us see what the law will say. Have you all these offenses? If you are found guilty, you will go in for a period of not less than 7 years. Let us proceed by fabricating that offense. Fabricating evidence. Any person who with intent to mislead any tribunal in any judicial proceedings fabricates evidence by any means other than perjury, knowingly makes use of such fabricated evidence, is guilty of a misdemeanor and is liable to imprisonment for 7 years. If you fabricate evidence, fabricating ni kupika ushahidi wa uongo, unatengeneza story ya jaba, inaweka mtu ndani. If you are found, you'll go in for 7 years. Section 114, false swearing. If any person swears falsely to make a false affirmation or declaration before any judicial officer, will amount to perjury and is guilty of a misdemeanor. If you are falsely swearing and you know what you are swearing is false. Section 115, deceiving witnesses. Any person who practices any fraud or deceit or knowingly makes or exhibits any false statement representing, token or writing to any person called or to be called as a witness in any judicial proceedings with intent to affect the testimony of such person as a witness is guilty of a misdemeanor. Here, there is a witness who is in court. You go to a cyber, you print false evidence. You bring it to court and tell him, have you ever seen this? What can you comment about this? And it's a lie. That document you are showing a witness is fabricated, is computer generated. That is deceiving a witness. It is a crime to deceive a witness when he is in court. If you are found guilty, that is a misdemeanor. What about destroying evidence? We talked about destroying narcotics, evidence. What about in a criminal matter? Section 116. Any person who, knowing that any book, document, or thing, or whatsoever, is going to be produced as evidence, you willfully remove, destroy, or renders it ineligible, you are guilty of a misdemeanor. Section 116. Have you hidden evidence? Have you destroyed evidence? Have you tampered with evidence? If you tamper or destroy evidence, my friend, you will be arrested and be charged with the offense of destroying evidence pursuant to section 116. And you'll be found guilty, you'll be convicted as a conspiracy. Then section 17, conspiracy to defeat justice and interference with witnesses. We talked about this thing when we were looking at the bond and bail policy guidelines. Most people are denied bail and bond because they interfere with witnesses. What does the law talk about interfering with witnesses? Any person who conspires with any other person to accuse any person falsely of any crime or to do anything to obstruct, prevent, pervert, or defeat the cause of justice. If you accuse somebody falsely, or if you pervert the cause of justice, your brother has been arrested. You yourself, you go and look for the complainant. You pay them. For example, in Northeastern Province, when one person has been killed, the family of the killer goes and looks for the family of the one that was killed. They pay what is called masla. They settle the matter. the witnesses don't come to court. That is interference and obstruction of justice. 2, you go and look for the witness who saw your brother defile a child. Then you tell that if you go to court, I'll hire Mongeke to kill you, or I'll kill you myself, or here is 5 million, don't go to court. Any interference with the witnesses in court is a serious offense. 2, if you do this and you obstruct knowingly, you will be, if convicted, you'll be imprisoned for 5 years. Any form of interference with the administration of justice in court, you risk going in for 5 years. Section 118 is what is called compounding felonies. Compounding felonies. This is a very serious issue. Any person who asks, receives, or obtains, or agrees, or attempts to receive or obtain any property or benefit of any kind for himself or any other person upon an agreement or understanding that he will compound or conceal a felony, or will abstain from, discontinue, or delay a prosecution for a felony, or will withhold any evidence thereof, is guilty of a misdemeanor. Compounding of felonies. Let me explain what that means. You have information, but you want to receive some money not to release that information. You are supposed to testify, but you are not ready to testify because you have agreed to receive money. You have been paid. Your child was defiled as a mother, as a father. You are paid some money. You don't go to testify in court. You don't want to produce that child because the child is not there. You are a mother. Your husband, who is the father of this child, has defiled that child. Then now you say, if I give evidence that indeed it is the father who defiled this child, people will say, ni kwa sababu you denied him conjugal rights. That is why he went for the child. You keep it quiet. You don't proceed. You go to withdraw the charges. It is a serious issue for children who are sexually defiled, and the parents do not want to pursue that justice. It is a serious issue for murder offenses where one of the person has been killed by a family member. Two brothers, one has killed another. Then the family sits and say, no. Already we have lost one. Do we lose another one to commit prison? It will not. Let us try to cover this story. People who try to cover offenses, it is an offense under section 118 called compounding felonies, and it will be a serious offense and you'll be arrested. If you are found guilty, you will go in for misdemeanor. Section 120 talks about advertisement of stolen property. If a property has been stolen and you advertise it, you know very well that property was stolen either from government, that property was stolen from Court Helicopter Properties, that property was stolen from any other person, and you go advertising it for sale. You know the car you are selling is a stolen car, but you are advertising it for sale. You will proceed and you'll be, it is found, it is related, it is called a guilty of misdemeanor. Offences relating to judicial proceedings. Now in court, offences relating to judicial proceedings. A. Within the court in which any judicial proceeding is being heard or taken, or within the presence of the same, shows disrespect in speech or manner to or with reference to such proceedings or any other person before whom such proceedings is being taken. This is a serious issue. My good producer Vivian tells me this should be an episode of its own, because we are dealing with you, the public, when you come to court. How can you land in court and be jailed? What are the offenses that you commit in court, not as an accused person only, but as a media person, as a general member of the public, as a person who has come to court? Wakili Danstan Omari always brings it. With the crew of Court Helicopter, we bring it to you live. Because Section 7 says, lack of knowledge, ignorance of the law is no defense in a criminal court. Keep watching, keep observing. Get your shoes, get your sneakers, get your running shoes, run away from crime. Because we said in the drug cases, narcotics, that the Kenyan law is stiffer than the American law. We are now telling you the Penal Code is more stiffer, more harder, and 2026, avoid crime. Wakili Danstan Omari from Court Helicopter News. Thank you.